My name is Jonathan Feniak. I am general counsel with the firm of called Company Sage. We are a Puerto Rico-based technology company. We create and manage websites all over the United States that provide entity formation services focused on privacy and asset protection. So we started out as a company that just did Wyoming LLCs. Actually, before that, a law firm called Cloud Peak Law, based in Wyoming, that was doing trust and estate services. The founder of the company was forming a lot of companies for his clients and decided that this was a great way to enhance the asset protection and privacy of the trust structures he was creating. And so he started moving towards more of creating LLCs and corporations in Wyoming. The business was very well received, focused on privacy. Wyoming is a state which does allow for the private filings of limited liability companies and corporations. Your name does not need to appear in the Secretary of State records. The attorney or the registered agent is required to maintain that information, but it is a great way to keep your privacy. And so seeing that opportunity, the founders of the company began to really expand their entity formation services, focused on, again, that privacy and asset protection, and wound up eclipsing the trust and other services provided by the law firm. The law firm is still there at the heart of the business. I am an attorney. I am licensed in the states of Colorado and Wyoming. But my goal is to create products that are, we'll call them quasi-legal products, where they are things that the average entrepreneur or founder or business owner needs in order to maintain their privacy as well as enhance their asset protection. And so we've created numerous products for the Wyoming LLCattorney.com website, Colorado LLCattorney.com website. We have state websites that are going to be launching in all 50 states shortly. And we also have a number of other sites that are not attorney focused. So we own Cindy's Florida LLCs, Cindy's New Mexico LLCs, and so on. And so the company Sage is the one that powers all of these different websites and allows our clients anywhere in the United States to form limited liability companies and corporations privately, and then also ensure that they are obtaining the maximum asset protection for whatever is in their business, as well as for whatever is in their personal name that they do not want to be affected by company obligations. Ultimately, there are, in our view, there's 6 different ways to protect yourself. So I don't know if that was enough about my bio, but we're gonna say that's enough. I'm an attorney focused on asset protection and privacy. When it comes to what the average founder or business owner can do, we think there's 6 different ways to protect yourself, protect your personal assets from business liability, as well as protecting your business assets from personal liability. And the first one is good liability insurance. That is most often where any plaintiff is going to stop. That is the person we're worried about. Worried about someone who was harmed because of your negligence, because of your actions, someone who was harmed by your company. So if you are a landlord and one of your tenants slips and falls, we don't want to really have to worry about your LLC and the protection. We're going to set it up so that we are protected, or we are protecting you. But ultimately, we want your liability insurance to be the bear the brunt of the attack. And if you have sufficient sufficient liability insurance, that is going to happen, and most plaintiffs are going to go away. But let's assume something terrible happens, and numerous people are injured, or even a death occurs. In that case, number 2 is separating companies from the owners. We want to isolate the risk related to that rental property from your personal assets. So you could be very wealthy. You could have a large investment account in stocks, bonds, mutual funds in your personal name. You could have a very valuable home. You could have valuable cars. You could have all sorts of valuable assets. If your company gets sued and you do things properly, then that liability is going to be limited to the assets that are inside of that LLC. They're not going to bleed out to the owners. Okay. And so starting that process, it begins with the formation of a company, but then there's much more that goes into that, separating the company from its owners. What we don't want to do is have you exposed to something called a alter ego attack. When someone tries to pierce the veil of your company, one of the things they're going to say is that really your company and you are one and the same. There really is no distinction. So how do you fight that? How do you protect against that sort of claim? Because if they are able to establish that you and the business are the same, then your personal home, your personal investments, your cars, and the like are going to be exposed to those risks. So you need to maintain good company records. You need to form your company, keep it in good standing, follow the laws of the state in which it was formed, and you also need to keep ongoing records, business records of the company. Business records, typically one of the most important business records to have is going to be a bank account. You have a company bank account, and that company bank account is where the rent checks will be deposited and the expenses will be paid. You're not buying personal groceries out of the business bank account, and you're also not taking the rent checks and putting them into your personal bank account. So everything happens in that business bank account. And then on top of that, when significant company decisions are being made, significant events are occurring, you're making a record of it. There's something called the business judgment rule. And if an officer or member or manager of a company exercises business judgment when making a decision for the company, I'm going to hire this contractor, I'm going to install steps that are this height, I'm going to, hire this contractor to shovel my sidewalks when it snows. You exercise business judgment in that, you're generally protected. You're not going to be held personally liable for that decision, even if the person who's supposed to shovel the snow doesn't show up, or the contractor does something wrong. You're generally going to be protected if personally, not the LLC. The LLC is going to be liable, but you personally, if you exercise business judgment. So how do you show business judgment? Well, you show business judgment by keeping adequate minutes and record of the company's decision making. A third element of asset protection, we've done one already, liability insurance. Two, separating companies from the owners. Three is anonymity or privacy, right? If someone is looking to sue or go after your company, first decision they're going to make is, how wealthy are you? Do you own 100 properties, or do you just own this one? Are you seen as someone who has a very is worth pursuing, that you have a lot to lose? That's where privacy comes in. And by forming a company in Wyoming and using us and using our services in other states, as well as adhering to some other basic tenets of privacy, we are able to make it unknown how wealthy you are. If someone looks you up, they are not going to know that you are the owner of 100 units in a particular city or across the country. What they'll know is maybe where your house is, your primary residence is, okay? They may know what you put on your website. If you put I'm worth millions of dollars on your website or talk about it in places like this and podcasts and the like, well, then they're going to know. But generally, we don't want to give those plaintiffs and their attorneys in particular anything to hold on to. We want to make it unknown as to how wealthy you are, and that causes them to adjust their strategy. Maybe they just take the limited life or the insurance coverage that you have and don't try to sue over that. Another item of asset protection. So the fourth item is something we call equity stripping, right? So remember the LLC itself. If someone slips and falls in front of your property, their first claim will be against the LLC and all of its assets. So if you have an LLC and it owns a piece of real estate free and clear, all of the value of that real estate is exposed to the claims of that slip and fall plaintiff. To combat against that, what do? Well, one of the easiest things to do is not own properties outright. Instead, own the properties with leverage, right? Have a mortgage on them, whatever you can get in terms of the LTV on the property, 60%, 70%, 80% LTV. And then if it's $1 million property, you're only exposed for $300,000 or $200,000 or $400,000. Readjusting your financing and doing cash out refinancings when the property values increase. We've seen tremendous increases in property values through the pandemic. So if you can evaluate your properties now and you're able to pull $200,000 of cash out of a property or some number that makes economic sense to you, you've stripped the equity out of that property, you're reducing your exposure. So that was number 4, insurance, separating companies from the owners, privacy, and equity stripping. The fifth is separating assets from one another. Having multiple pieces of real estate in a single LLC exposes all of them to the risk of one slip and fall. So you have 4 properties in one LLC and someone slips at property number 1. If they sue, they're going to get all the equity potentially, and they're successful and exceed your policy limits. They're going to get all the equity in all the properties. So if you have 100,000 in property 1, 100,000 in property 2, 100,000 in 3 and 4, they get $400,000 of equity to satisfy their claims in addition to your insurance. Now, the alternative would be 4 LLCs, and then you've got 100,000 of equity. That's all you're exposed for. If someone slips and falls on property 1, that's all you're exposed for. So that is number 5, separating assets from one another. Another is the 6th item is separating ownership from management. And if we think about what typically leads to litigation, there's 2 things, right? One is going to be inherent defect in the property itself. Okay, something was just wrong with the property. An example is that when the building was built, it was improperly built, and this is decades ago, right? Decades ago, the property was built, and it leads to a collapse, catastrophic collapse. That had nothing to do with management. That was a condition of the property itself, which the property owner is going to be liable for. Most liability, buildings aren't falling down all the time. It does happen, but they're not falling down all the time. Most slip and falls and negligence claims by plaintiffs are actually related to negligent management, right? The sidewalk wasn't shoveled. A carpet wasn't nailed down properly. An electrical outlet perhaps was not grounded properly. Those kinds of things. The hope is that the manager can be held liable for that liability. And if you have a management entity, which many of our real estate clients do establish, a management entity would bear the brunt of that liability. The property owner, with a properly structured agreement, would have an agreement with the property manager. The property manager say, I take all responsibility. I'm responsible for any injuries that occurred due to my negligence, failing to shovel the sidewalk, and so on and so forth. And in that way, you're able to have effectively 2 insurance policies for the same property, right? You've got your manager insurance policy, right, which is going to cover for a lot of those negligence type of events. And if the manager is found to be really extremely negligent in some way, and it exceeds the policy limits, that management company doesn't own anything, right? Doesn't own any assets. Maybe it owns, I wouldn't say an office building, it owns a couple computers and maybe a desk. The property owning entity may be held liable for some percentage of liability, 20%, 30% liability, depends on the state. Are they jointly and severally liable? Who's responsible for paying? But it could lead to a situation where none of the equity in the real estate is exposed to the claims of or the claims of that plaintiff, but the property manager really bears the brunt of all of those. So all of these things together, your insurance, easy peasy, everyone does that. Separating companies from the owners, everyone should do that at the most basic level, have a single LLC. Privacy is easy to get if you use our services to form your companies. Equity stripping just becomes a sort of a way of life, and constantly or consistently, I should say consistently doing cash out refinancings to minimize your equity in the properties, and then separating assets from one another. Fairly easy to do. Management winds up being the one, setting up a management company. Typically, my clients aren't doing that till they're hitting, 5 or 10 properties, and then they want to reduce their exposure further. And there's some other benefits to having a property manager. Licensing laws vary by state. As I said, I'm licensed in Wyoming and Colorado. Typically, most states, if you own the properties, the ownership is the same, then the manager does not need to be licensed, but check with a local attorney in the state in which you're located. Can you set up your own management company? So you take all of these things together, and it doesn't need to be all or none, right? One of the things that you can't get back if you lose it is going to be the privacy. If you form a company that's not private from the start, okay, your name is forever and always going to be connected to that LLC. We form companies privately. That's what we focus on. So your name is not connected to that LLC. I see a lot of times that clients will purchase properties in their personal name and then do a quit claim of the property. They'll transfer the real estate into an LLC. They do that for the purpose of obtaining a lower rate or lower down payment mortgage on the property. That's fine. You have to understand the risks of doing that, right? In a perfect world, what I would say is get a commercial loan, get a loan that names the LLC, the acquisition of the property occurs in the LLC, it's a privately formed LLC, and in that way, your name is not forever and always connected to that LLC. So these 6 things together, you can also, on top of this, create a holding company structure. And a holding company structure can make your life easier from a tax perspective, as well as create an additional layer of protection. So let's give an example. Me and my sister want to purchase real estate together. We say we're going to go 50-50 on everything. We've got a pot of money that we want to invest in real estate, and we're going to target 10 properties we're going to buy together, but they're always going to be 50-50. What we could do is form an LLC. We're going to buy a first property in Colorado, second property in Texas, third property in Florida. We could form an LLC in each state. Each LLC would be 50-50, therefore it's a partnership, okay? And then we would file a Form 1065 annually, costs associated with that, and then issue a K-1. So at the end of the year, we would have 10 filings we need to do with the IRS, and we would have 10 K-1s we need to put onto our personal returns. The alternative would be a Wyoming LLC as your holding company. Wyoming holding company has me and my sister as the 50-50 partners, but then it goes and forms Texas LLC, Colorado LLC, Florida LLC as single member LLC. So each of them have one member, okay? In that case, they don't have a Form 1065 partnership return requirement. There will be a filing requirement for the holding company at the state level to report that Colorado or Texas or Florida source income, but it does relieve a significant amount of the burden of your limited liability company reporting. Okay, so a holding company structure is easier from a tax filing perspective, and it also is much more protective. Let's assume that you messed up in some way. Someone is injured in your Florida property and they're able to sue. And you were lax in your record keeping when it came to your Florida LLC. Maybe you bought some groceries out of that bank account, or some of the rent checks went into your personal account. They would be able to pierce the veil of your Florida LLC and potentially hold its owner liable for the claims against that Florida LLC. Well, in this case, they would only get to Wyoming. They wouldn't get to you personally. And so you are going to be able to protect your personal assets from these claims, and you should be able to protect the sister company assets from those claims as well, because of a number of different features of the law in terms of can they claim the assets of subsidiaries and so on. So we don't want you to get in that situation. We like to have the recommend different record keeping requirements, and we do offer them on our website. But ultimately, if it does happen, we're going to leave you in a place where you're able to go on and fight another day, because you're not going to lose all your personal wealth as well. So we do have some questions which came in. Kevin asked, do you recommend having your own home in an irrevocable trust and LLC, or just in an irrevocable trust? I gather you should always have umbrella insurance. The last item, yes, you should always have your home, or you should always have an umbrella policy. Now, the question of does it make sense to put a primary residence into an irrevocable trust is one of the common questions we get. And the problem with moving a primary residence into an irrevocable trust is it's no longer your primary residence, right? Is it a trust asset, or is it your primary residence? For your primary residence, there's a number of benefits which come from something being your primary residence. You get in many states a homestead exemption. California just raised it. I'm not licensed in California, but just raised the limits to 600,000. Someplace like Florida has an unlimited homestead exemption. And the question is, would you obtain that type of protection if you had your primary residence in an irrevocable trust, because it's not your homestead, right? Now, if it's an asset protection trust, which is what many of the irrevocable trusts are, and we do create a asset protection trust for our clients, you now run into the problem of you are using a trust asset for your personal benefit, right? So is it a trust asset or is it your asset? If you are staying in this building, it could be your primary residence, but it's not yours, right? Are you paying rent to the trust? Otherwise, it's a distribution. It's either going to be treated as an ongoing distribution from the trust, but more likely what would happen is it's treated as if you are commingling trust assets, your irrevocable trust assets, with your personal use. And so you undermine the asset protection trust, and you potentially also remove it from that homestead exemption that you were looking to obtain. So for most folks, what we recommend is keep the primary residence in your personal name, reduce the equity strip on it, right? So you do a cash out refinancing, have a HELOC on it, whatever you can to get it to where it's the minimum amount and hopefully the protected amount. And then you can take that cash, that excess cash, and put that into an irrevocable trust. And this way, if someone comes after you, you've been making your payments to Wells Fargo, they come after you, they get some huge claim against you. They can take your house, maybe if the equity value is above the homestead exemption limit for the state, but they aren't going to be able to go after that cash that's in the irrevocable trust because you didn't commingle, right? So the irrevocable trust will be off limits. And when I say cash, it doesn't need to be in cash, right? You could take that and go and reinvest it in commercial real estate or stocks, bonds, mutual funds, crypto, whatever you want to do. I think I answered that question. So I'm going to type done. Do you suggest equity stripping by creating any, have it put a mortgage on the asset? As a last resort, right? So I think about the efficacy of there's friendly liens. I see that online. Put a lien against your house, and then, no creditors are going to come after. I think if you have an aggressive creditor who is coming after your assets and going after your home, we call that blood money, right? They went after your company and now they're out for blood. So they're coming after you. If it is a bona fide loan from Wells Fargo, they're going to see that. Wells Fargo home mortgage has a lien on the property. There's nothing there for them. If though you owned the home outright and then you did a friendly lien on the house, you just put a mortgage on it for the 100% of the equity value or 90% of the equity value in it, I think that's going to be scrutinized. They're going to look at that and say, what is this person worth? And they're going to look at that entity and they're going to say, is this a licensed mortgage lender? They're going to look at the entity and they're going to say, was this a bona fide loan? What makes a loan bona fide? Well, there's half a dozen things, even more, that a court will look at to see if a loan is bona fide, because this is a way that especially debtors attempt in bankruptcy to avoid having assets included in the bankruptcy estate through these bogus loans. And if it's a bona fide loan, it needs to be for value. So just putting the mortgage on the house without funding ain't going to work, right? So if you have a lending entity, the lending entity loans money to you or loans money to one of your rental properties, okay, did the money actually go from the lending entity to the borrower? And that's when the mortgage was secured. So show me a transfer of the $500,000 for this mortgage. And then show me that it's a bona fide loan by having payments go every month to your lender. I've seen people try to do it. And there's some of my more sophisticated clients have been able to do it with great effect. But I've also seen many who, when they were like, no, I can do it. And then a year later, okay, show me proof of the 12 monthly mortgage payments you made. They're like, I only made about 6 of them. What would happen if you didn't make 6 mortgage payments to Wells Fargo? well, they would foreclose, right? And so it's not a bona fide loan then if the lender also doesn't do things like enforce its rights, foreclose on the assets, and so on. And so if you have the wherewithal to treat it as a real loan between related entities, that's okay, but it better be bona fide and it better have been for value. That is sort of a last resort. And I do have some clients, very low, high wealth, but low income. They basically can't qualify for the mortgage. And those folks, as a last resort, is it better than nothing? Yeah, it's better than nothing. But I have serious doubts about its efficacy, especially in real world situations. It looks better on paper than it does in reality. There's a Yogi Berra quote in there. In theory, practice, I forget what it was. So that would be my guidance. Get the cash out financing from a traditional bank. If you don't like owing money to a bank, what you can do is take that cash out you got, put that into another LLC, invest it in muni bonds or something that yields the exact same interest that you're being charged on the loan. And so it basically zeroes out, but you have the cash available if you ever need to pay off the mortgage or you don't like it, right? So you don't need to do something with the money to lever yourself up. If you like owning things cash, have the cash sitting in a separate account. When it comes to asset protection trusts, Wyoming is one of, there's 10, 12 states that allow for self-settled trust. And a self-settled trust is what an asset protection trust is. Some states don't allow them. Self-settled trust means that I have the money, I am the grantor, I'm the one establishing the trust, I'm putting my money into the trust, and that money is not available to pay my personal claims. So if I want it to be the truth that it's not that I can't use that money to pay personal claims, I need to treat the money as if it is not mine. And many folks who set up, in the cases where I've looked at where there's been irrevocable trusts that have been pierced or broken or cracked open, they have created the irrevocable trust, said that it owned all these assets, and then they were just using them like they were their own. They would just, have a debit card against the trust assets, and they'd run around and do all sorts of transactions, personal transactions with trust assets. That's not going to fly. If you want the irrevocable asset protection trust, self-settled trust, also called dynasty trust, to really work, there's a number of different things which you need to do. And they are, you're able to manage the assets in the trust. That's fine, right? No one else needs to be able to touch them. You don't have to turn over control to some independent trustee. We established our trust with a private family trust company. That's a Wyoming. There's very few states that allow them. The private family trust company in Wyoming, it's a robust statute and it's very easy for an individual to administer. But basically, you create an institutional trustee for your personal trust that only works with your trust or your family's trust. And it is the one that manages the investments and manages the trust assets in a way that you determine is most appropriate. You can do everything within the shell of the trust with that trustee. The only thing you can't do is give yourself the money out of the trust. For that, you need an independent third party. And it's we establish our trust with a discretionary distribution committee. That discretionary distribution committee has to be non-subordinate individuals. So it can't be a family member. It can't be your employee. So we will serve in that capacity for our clients. But when an individual wants a distribution from their trust, they will request it and say, I want $100,000 to take my family on an around the world cruise. So, all right, that's great. No problem. Signed off by the distribution committee. Same individual comes with a request from a court. They say, I'm being compelled to distribute $100,000 to this judgment creditor of mine. Distribute the money. The discretionary distribution committee would say no, because that would violate the terms of the trust, and hand that back to you. And you can go to the judge and you can go to the plaintiff's attorney and say, can't do it. It's not within my power to make this distribution. So therefore, you're not in trouble with the court, and that plaintiff doesn't get the money, and the sanctity of your trust is protected. Someone has asked a question about how does a foreign national do asset protection? I am a Canadian at the same time. I need to avoid double taxation. So one of the interesting things is, and I often work with clients who have LLCs, but if you are looking to avoid double taxation, one of the things that you can do is set up a corporation. Right? Corporations are actually, they see all the stuff online and it's about, double taxation. I'll be taxed in the US, I'll be taxed in the, or I'll be taxed at the entity level, and then I'll be taxed on distributions. But a lot of our foreign clients establish corporations and then pay themselves on a 1099 basis. Right? So your corporation, let's say, makes $100,000 in income, and then it pays you as a consultant or as an officer of the company, pays you on a 1099 basis to be the officer of the company, and gives you $100,000. It pays you on a 1099. Here's your 1099 for an individual, and that foreign individual then claims that on their Canadian tax return. But it's a deduction for the company, right? The company would have 100,000 of income. It would report that on its form 1120 as being 100,000 of income and $100,000 offsetting expense. Zero out. Corporation has zero income. You have $100,000 on your income on your foreign tax return. That's one of the strategies our clients will use. You also have to think about, an LLC as a pass-through entity is taxed based on, or the owners are going to be taxed based on the income of that entity, based on either the location in which the income was generated, or they will be taxed based on where they are located. And so if we think about a foreign individual who perhaps is doing nothing but online sales, there may be no US source income. And some of our foreign clients are selling globally and they don't have any US source income. The income comes from, India, goes through their Wyoming LLC and flows to them in Canada. There was no US source income and they're not located in the US. And there would likely be a no income tax liability there. Now, foreign individuals owning an LLC or being a majority shareholders in corporations, when I say there's no tax payment requirement, filing, it can be complex for non-US persons to own domestic LLCs. And so you have there's a form called 5472. Those non-US persons would have to also compel or make the entity file potentially a form 1120. There's a number of different filing requirements. We work with a group called Online Taxman, and they're great for non-US persons. They have individuals located all over the globe who have knowledge of Canadian tax laws, how they interact with the US tax laws, and they can provide you with guidance on that. We don't prepare tax returns for international clients, but we are in the process right now for domestic clients working on a assistance with both bookkeeping and tax filing for US persons. So hopefully that answered your question. Rama, thank you very much. It was a pleasure speaking to you as well as the other participants here. And if you do have any additional needs, you can go to our website, Wyoming LLC Attorney. We've got about 1,000 pages on the website written or reviewed by attorneys. And so we're very confident in the information we provide. And then if you wanted to schedule time with one of our attorneys, so if you wanted to schedule time with an attorney, you would go to wyomingllcattorney.com/attorney-consultation. And at that page, you will find a list of half a dozen different attorneys with different specializations. If you have a complex issue of planning, if you have general entity questions, if you have questions related to trust or crypto or litigation or just about anything, we have an attorney who you can schedule time with and then talk to you about the products we offer that would be a good fit for you based on your particular situation. So the company that specializes in foreign tax filings, they asked for it. Yes, they're called Online Taxman. So Online Taxman.